PMC, the child fighting mother litigation friend, FLR, and a local health board.
Good morning, Mr. Hine.
May it please, Your Lordship, my Lord Master of the Rolls, my Lord and Your Ladyship. I now make submissions on behalf of the respondent to this appeal. The respondent recognises that the issues in this case are indeed complex, difficult and important, and acknowledges that was why, when granting permission to appeal, the judge below, Mr. Justice Nicklin, the reference is core bundle, closed bundle, reference 331, it's the same in the open, indicated that he was granting permission on compelling other grounds, including the potential that he thought that his judgment and certain decisions of the Court of Appeal at appellate level conflicted with JX-MX. And my submissions, broadly, are directed both at the particular facts as were under consideration, but from a position of neutrality, and at the wider issue, which is whether indeed JX-MX is good law or should stand, and indeed PQ, which is the approach adopted by Mr. Justice Martin Spencer in the position which isn't governed by it doesn't fall into that category of approval hearings under CPR 21.10. Now, while maintaining my neutral position, may I just make a few preamble points and then really try and make some bullet point submissions, and I'm going to keep my submissions really quite short. The first point is that any assessment of the judgment on appeal must, we say, focus on the order that was initially sought in order to understand the judge's reasoning and why he responded as he did. And that order is in the supplemental bundle at pages 134 to 138. And the reason I turn it up, or ask you to turn it up very briefly, is just to note that in this initial order, anonymity order, based, I think, on PF10, at page 135 in paragraph 1, it begins, the identity of the claimant as a party to these proceedings is confidential and shall not be published. And that is how the application...
Sorry, what's that? Where is that?
Sorry, I'm reading from page 135, two-thirds of the way down. This is the draft order sought on the application.
The identity is confidential.
Indeed.
Yeah, sorry, yeah.
And so just as a matter of fact, the way the application was initially framed was it was expressed as a confidentiality-based order. And for reasons I'll come on to, that may be or may not be relevant to how the court views the issue of jurisdiction. The second point to note is that there were then some directions made, and they are summarised. I haven't been able to find, although they may be in the bundle, the directions themselves, but they are reproduced in the appellant's, or the claimant's as it then was, submissions at supplemental bundle page 217. And this is where the interim, and this is top paragraph 10, this is within the claimant's submissions, as then was, the court, under the third line, fourth line, the court refused the interim application, setting out the reasons for refusal and gave directions for the hearing of the application. And all I will just ask you to take from that is you can see that the judge was seriously concerned at this being a freedom of expression in conflict with Section 12 of the Human Rights Act application, and at C was concerned about the statutory basis and the effect of pre-publicity that had been referred to in the relevant statements. And I only make that point just to draw the distinction between that order which was sought then and supported by a skeleton argument and argument for the judge, and the order that is now put before this court at the bundle closed or open, page 55 to 58, the one with the blue headline.
Which bundle?
It's called, well, I'm using the closed bundle, but the pagination should be the same in the open bundle. It's at page 55.
We're in the core bundle.
Court bundle.
Core.
Yeah, core.
Closed core bundle, yes. Core bundle. At page 55, it begins, and that's the one with the blue highlighting. Can I just check that that we've found that document? Simply
What's
to
the
say,
blue highlighting about? What is the blue highlighting for?
well, that I think
Optional
is.
bits, isn't it?
That was a submission I made yesterday, my lord. That was to highlight that it was not necessarily our case that it would have retrospective effect, and it
That.
could have simply prospective effect, and we highlighted the relevant passages which could be kept in or removed.
Exactly, and so what those blue highlighting show, and are reflective of the oral submission yesterday, that the claimant is effectively taking the risk of jigsaw identification. I'm going to use the phrase on the chin, but as one of those things that will just have to happen. And that's why I think, or my understanding is, at page 57, the wording under paragraph 3 of this suggested draft order at the top of our page 57 in blue is that without being taken in combination with information published about the claimant before the making, this order is intended or likely. In other words, taken by itself and regardless of any prior publication. And that clearly is a very different order, but it's important to understand just how, when you read the judgment, this is Mr. Justice Nicklin's judgment, and if I could just give two examples, how important to his rationalisation of the application, his decision, was the concern about jigsaw identification. And that is picked up at core bundle, page 291, paragraph 59. A paragraph beginning, even if the court takes care to prevent the reporting restriction order from having retrospective effect, that paragraph. And he then goes on to give detail of specific concerns about how that risk is very difficult to mitigate against. And in similar effect within the judgment, and again I'm not going to read out paragraph 151 at page 314, when the judge is again looking at, and this is in more general terms, his approach that he's discussing, the court must focus towards the bottom of the page. The court must focus on and assess the impact of that jigsaw identification would have on future reports. For that purpose, any applicant seeking reporting must file, etc., etc., etc. So that was clearly a fundamental concern that the judge had. And while I'm not making detailed submissions one way or the other, it is clearly relevant to the is it necessary or is it simply desirable when you apply the necessity test, which all are agreed has to be applied. The second preamble point I would like to make is that in terms of jurisdiction, Lords Reed and Briggs, we say, and I'm sure there's probably no dispute about this, that there is a proper recognition of the different uses of the word jurisdiction when talking about this kind of issue, as between the power to decide and the principles governing the exercise of that power. And that is Wolverhampton at paragraph 16, Authorities Bundle 1095. I'm not going to turn it up, but that's a clear and important distinction. Third preamble point, in terms of Wolverhampton, the defendants observe that it is undeniable that it does, or the court in that case, does draw a distinction between the Venables type equitable injunction, which is described as being based on a restraint of breach of confidence or privacy, and what are then described as reporting restriction orders, paragraph 34, and embargoes, paragraph 35. That distinction is there. In our submission, that distinction is between equitably restraining a threatened breach outside the court proceeding and preserving the integrity of the court's process from abuse. And I get that phrase from a later paragraph in the same judgment, which is at 158 of that, of Wolverhampton. Just double check that I've given you the right reference.
So can you give us the page number?
Your page number 1135 of the authorities bundle, paragraph 158 at H. It may be said correctly that orders of this kind, it's talking about embargoes at this point, are usually made so as to protect the integrity of the court's process from abuse. And is talking about in terms, of course, that case about injunctions against persons unknown, gypsy, traveller type injunction, the main focus of that case. The upshot of that distinction in the defendant's submission is that an RRO, a reporting restrictions order, can be made under what I'm going to call common law powers, or under the equitable jurisdiction, as described the Venables type jurisdiction, if it's restraining threatened breach of confidence outside proceedings, and that the principles governing the exercise of the discretion may be different and are bound to be highly fact sensitive. And I may say, well, that's trite and not very helpful to us, but I'm trying to just sketch out that the difficulty is in pinning down precisely what jurisdiction is being exercised in a particular case. And the A and BBC case, I think Lord Justice Warby observed, it's quite easy to understand the traditional blackmail case and a pseudonym being used to withdraw the identity of the person from the court. In the same way, A and BBC is quite easy to understand that publication of A's name would completely subvert the whole purpose of the proceeding. It would render the proceedings to no purpose. And there will then be a scale as you move across to whether the jurisdiction being exercised is properly protective of the integrity of the court process, and within that concept, discrimination in access to justice and the court process. And I'm using that phrase to pick up on the thinking in JX and MX about the level playing field for persons under a disability when being dealt with in an approval hearing. And the final preamble point I would like to make is that there's no real dispute that when it comes to open justice and derogations from it, the test is generated, one sees it in several of the cases we've got, for example, paragraph 41A and BBC, and the structured approach as...
Sorry, paragraph 41
of A and the BBC, authorities bundle page 615, and in the structured approach within Abbasi at paragraph 128, the relevant page number for your note for 128 is 1264. There may also, I should say, as to the RRO power or jurisdiction, is there a power, there may be overlap. So at any particular moment, it might be possible to say this order is being made under common law powers or under inherent jurisdiction. And I should say I'm using inherent jurisdiction and common law as in interchangeably. I'm trying to distinguish between the use of equitable injunction used in the Venables case, or how Wolverhampton have defined the Venables case as an example of an equitable injunction, and distinguished it from an ordinary reporting restrictions order. Now, as per our skeleton, in the light of that preamble, our position generally is this, that contra the judge's view in respect of Cuja, paragraph 18, there is a power within an inherent power in the court to grant an RO, but the scope and the ambit of that power is not clearly defined. It seems to be for preserving the integrity of the court's process. That's one source of power. And we think that Cuja can be distinguished in the light of Wolverhampton and Abbasi. And in Abbasi, one sees the court searching for sources of jurisdiction and hits upon three, whether it's Broadmoor or Section 37 or the parents patriae jurisdiction.
Sorry, how can Cuja be distinguished?
Because it is focused on disclosure that has already been made in open court proceedings that have already taken place. There's been a hearing, the matters have been disclosed and revealed in an open court process, and that is not the same as the situation with which we're confronted.
It might be, though. I mean, is it not diametrically opposed to the clear statement in Wolverhampton and Abbasi that there is a common law power to make reporting restrictions order, let's call it, to preserve the integrity of the court's process, and Cuja says there isn't. I mean, I don't understand where distinguishing comes in. You may say something different, which I'd have some sympathy with. Well, the Supreme Court has not tackled the difference. Maybe it wasn't required to in Abbasi, but we are required to, and it's quite clear, you may say, I mean, I don't know if you do say this, I think Mr. Weir says it, that the direction of travel of the present Supreme Court is definitely on the line of Wolverhampton and Abbasi and A and the BBC, whereas it may not have been in the past. But I don't think it's possible to look at independent, if that's what the name of the case is, in the Privy Council, followed by Cuja, as being anything other than saying something different. I mean, we have to call a spade a bit, don't we? I mean, it's all very well dancing on the head of a pin, but ultimately this point has got to be decided.
My Lord, I would respectfully agree. Certainly it is correct that the judge's approach was to feel it's clear as daylight what Cuja says as to the scope of any common law power, and it doesn't exist. And that seems to be contrary to the approach in Wolverhampton and the distinctions that have been in that full fundamental review. I mean, when one reads Wolverhampton, one sees how the judgment is set out, which is to consider reporting restrictions as examples of contra mundum type orders, with a little subtext saying, well, they're not really like injunctions, but they affect the world and they can be punished by contempt.
I mean, you may not know this or remember this, but Wolverhampton, when it came to this court, was an appeal from Mr. Justice Nicklin, who had refused the injunction.
No, I was alive to that.
And that's not a criticism. Again, it was a good judgment.
Well, suffice to say, my position is, not least because my position on the wider issues is that whatever your conclusions are on jurisdiction, I'm inviting you to, I've tried to emphasize in my skeleton about consistency. Consistency is incredibly important. There are vast numbers of these cases, you will know, that come for approval every day in the High Court, where frequently anonymity orders are being sought.
Maybe not vast. Maybe that's a slight exaggeration. There are many.
There are many.
Yes. Yes. This is serious.
So I say that our position is we think Cuja is either distinguishable, or if it comes to calling a spade, it is in fact inconsistent with the position in Wolverhampton, which was a fundamental review of the authorities. Although Wolverhampton nor A and the BBC comprehensively answers the question, what is the scope or ambit of that common law power? And it may be that the advocates of the court will make submissions as to how that bit of the common law fits in.
Well, I mean, it's dangerous to draw a very, very tight distinctions because of the danger that a case arises which is obviously somewhere on the penumbra and should obviously be decided one way or another, but doesn't fit some very tight guidelines. But do you disagree with the proposition that the purpose of a reporting restriction order under the court's inherent jurisdiction, common law, to derogate from open justice is to preserve the integrity of the court's process? And that's one way of putting it, or to protect the court's procedure and proceedings and ensure that it can do its work appropriately. I mean, we can find all sorts of formulations, but they will be general formulations because we are not seeking to draw a very, I mean, you cannot draw a box for all times with very hard edges. But it's about, so long as one understands what the jurisdiction is about and why it's being, why it is there, then the court will apply it in an appropriate way in future cases, which will be different from this one. I mean, is that?
Well, I don't disagree with any of that.
I mean, that just seems to make sense to me, and it's sort of, in a way, it's surprising that approach has been lacking up to now.
Well, can I then build on the next point, which is, again, David Muscella, just to clarify what my position is.
Yes.
It's slightly complicated, this, when the Section 11 of the Contempt of Court Act is brought in, and this tension between whether or not, as per judgment, paragraph 61 to 3, unless a withholding order is made at the outset, there is no power to grant a reporting restrictions order under Section 11. I just pause to say maybe that doesn't matter, because if the court has the jurisdiction and the power to protect the integrity of its proceedings, it doesn't need Section 11 to do that. So to some extent I'm neutral on this point, and I've said in my skeleton that 61 to 63 seems to be correct. Certainly it is true that Lord Justice Judge in Repress Association and in Trinity Mirror, respectively, and you've seen the paragraph, you've been taking this already, but the references are paragraph 12 in Repress Association Authorities Bundle 595 and paragraphs 18 to 19 of Trinity Mirror.
So how do you apply that, if that's correct? That you I mean, how do you know how much before it's got to have been made? I mean, when does the big shutter come down and say you can no longer use Section 11? You can't make an anonymity order. Can I just ask you another question before you answer that? Is there any difference between a withholding order and an anonymity order?
Well, I have understood, this is a personal submission really, an anonymity order to encompass the twin effect of a withholding order combined with a reporting restrictions order equals an anonymity order.
Oh, really? Okay. Well, I sort of prefer the use of the word anonymity order to mean deleting the name, since anonymous means a person without a name.
No name.
And I find hugely confusing the code, which has never before been expressed to me, what you've just said, which is that a withholding anonymity order equals WO plus RRO.
Well, maybe
that's something-
I am not being. I think if analysed by itself, that is what you said is correct. But generally, the PF10 form, the way that these are dealt with in clinical negligence cases, is a combination of withholding and reporting restrictions. So withholding from the court file.
Withholding of what?
Withholding of the name. Ciphers for the claimant, ciphers for the carers or parents and litigation friend, and in some cases ciphers for some others if there's a particular risk. The defendant then, the trust usually, the hospital is usually named. So the anonymity is in respect of the claimant and his family.
It is confusing, isn't it? I mean, just for the person who comes to this afresh, you know, some old master of the role. I mean, I really would prefer to have clear terminology. I mean, if everybody agrees with what you've said, then I would propose to make clear in my judgment that this terminology is not very helpful, and to make clear what I'm talking about, whatever terms we use.
Well, I have said in my skeleton that the judge's distinction between withholding order and reporting is a helpful one. It's actually clarified what was before a bit of a fudge. People weren't quite sure what they were talking about.
If withholding.
Can I just, I confess that I used to be where my lord was, but I reread Dartford, not for the first time. Dartford in paragraph 32, Lord Justice Morbick says, an anonymity order by which we mean an order prohibiting the publication of the claimant's name and address and a restriction on access by non-parties to documents in the court records. So in slightly different ways, he certainly, and that court, thought that there were the twin components of taking the name out and preventing publication.
I'm extremely grateful
So maybe that's
for that, and I'd much prefer to go with the Court of Appeal's definition of what they mean.
Well, hang on, I don't understand it. An anonymity order, by which we mean an order prohibiting the publication of the claimant's name and address, okay, and a restriction on access by non-parties to documents in the court records. Yep. Well, that is not a reporting restriction order. That is restriction on access by non-parties to documents in the court record.
And that's a direction that's very commonly made, I think, isn't it? Consequential on the what we might call a withholding order, because you substitute the name of the claimant, the cipher, and that's what's then accessible on the court record. So I think that's what it's referring to.
No, I can see that, but I mean the reporting restriction order would be an order saying the press are not injuncted from reporting what happened in court in this case, right? By in some way or another.
But that's the sorry, my lord. That is because the whole point is the press is entitled to report what happens in court, but what they're not entitled to report, the prohibition is on the publication of the claimant's name and address.
Right.
And they can. I think. I don't know if that helps.
Is that just that? Because if we look at the order that's sought here, it goes further. No, I mean it's really important.
It is really important.
Because we don't. One thing we don't want to do here is just by ignorance of, you know, if I can put it this way, you have years of experience, and so does Milady, of doing these cases, but some of us don't, and we don't want to say things that don't chime with people who do. So it's extremely important that you tell us if we're out of step.
Well, the position is set out by Mr. Justice Nicklin at page 288 in the core bundle, paragraph 45, under a heading Anonymity Orders.
Sorry,
288 of the core bundle, my lord. When I say it's a position, what I mean is it is a position, it is the language which is commonly employed. In other words, the language commonly employed is to treat an anonymity order as involving both a withholding order and a reporting restriction order. That's it. That is the common understanding to date. And the observation of Lord Justice Moore-Bick was, in one sense, and I don't mean this rudely, but incomplete, because it actually focused on the reporting restriction order aspect without saying first...
Not the withholding order bit.
But
But that is implicit in there. I mean, it's only really to say that it was to pick
and to include.
It's where you directed me yesterday when we first came in, was to say it's not just about preventing discovery, it's a bit more than that.
It is, my lady.
It's preventing publication.
My Lord is undoubtedly right that if you look at the word anonymous in the dictionary as to what it is actually doing, it's achieving the withholding of a name.
Yeah. But
the term, an anonymity order, is well understood, exactly as set out in paragraph 45.
Well, I'm extremely grateful for that intervention because the judge, again, has, I think, clarified that the twin components of the anonymity order, I think, are, and I would agree, correctly
So do
summarised.
the parties want us to perpetuate that terminology in 45?
It's convenient, my Lord, in this sense, that what one is doing is saying, I'm going to seek an anonymity order, and the court would then say, okay, what type? Or are you seeking a withholding order and or reporting restriction order? Otherwise, you have to say, I'm seeking an anonymity order and a reporting restriction order. And so you have to say, take it in two steps, whereas what you're seeking is some form of anonymisation, complete or partial. That'd be the way that we might approach it, my Lord.
Okay.
Your Lordship's in charge of not just this, but also
Well,
the
it's
civil
because of
procedure
the word
rules and can change.
anonymity. Anonymity means anonymity. It does not mean a withholding order plus a reporting restrictions order. So, I mean, we could, since we're setting things aright, hopefully, for the future, we could change the terminology. But if you're all agreed we must not, then we must not, I suppose.
Well, I'm not going to say you must not. That would be putting it too high. All I can say is that the common practice is to, if I am in court tomorrow seeking an anonymity order, it would be commonly understood within that clinical negligence context that I'm seeking a combination of a withholding order and a reporting restrictions order for the reason that by itself, as explained by the judge, Mr. Justice Nicklin, the withholding order has no coercive effect.
No, of course.
And then we'd need to distinguish between that bundle of orders, whatever label it gets, and an order made under the equitable jurisdiction of the Venables type, which is sometimes described as a reporting restriction order as well.
Indeed it is. And this is the nature of the terminology. And when one says, what is an RRO, in my submission, it encompasses, that will be called a reporting restriction order, although it's subtly the source of its jurisdiction may be different to the anonymity order it's granted to protect the integrity of the court proceedings.
May I just add that one other opportunity for the court, only should it choose to go this way, is if the court were to consider that CPR 39.2.4 accurately, as per our submission, provided the court with confirmatory jurisdiction to make a withholding order and an RRO, then that is using terminology of non-disclosure, in line with the practice direction that Lord Newberger promulgated in 2010. So not using language anonymity, but using language of non-disclosure as an option for the court, which would ally with the civil procedure rules. So far as concerns the issue of an RRO in other contexts, I would invite the court to adopt the observations of the Supreme Court in Abbasi and to distinguish between RROs, which occur in the conduct of court orders, and those things called equitable injunctions, which should not be called RROs.
That is all clearish.
Well, I'm not going to be the last person to speak on this, so you'll hear from others as well.
No,
with their
everybody has a view.
But may I just try and just finish off my point about, because I think you should ask me, well, how can that make sense? How do you know? This is the point about withholding order must be made at the outset of proceedings. I think our position is that's what the Court of Appeal decisions, plural, the Lord Justice Judge, say. The logic behind them appears to be, and this is effectively unusual, that once exposed in court proceedings, in other words, not withheld, it is known and later attempts to withhold the same may be far more problematic. But in the BBC is an example of a judicial review where it hadn't reached paragraph 20, I'm not going to turn it up, but paragraph 22 of that decision, it just tells you that it hadn't reached the first judicial review hearing at that stage, but some form of withholding order was made. But our position neutrally can be distilled, I think, into two sentences, which is this. The reasons given by Nicklin appear to be correct and justified on the basis of what the Justice Judge says, but even if he's right about that, it doesn't mean that JXMX is not still good law, because in order to make the reporting restrictions order, non-disclosure order, anonymity order that we're talking about, in the JXMX situation, we are within the inherent jurisdiction and not precluded from making the order by the absence of a statutory basis. So the end point of my submission is, even if 61 to 63 is right, JXMX should remain as the approach using the inherent powers certainly for the approval process. The best way of describing it, and I agree with Mr. Weir, is that it is akin to the parens patriae jurisdiction. The reference is JXMX paragraph 29 at C, authorities bundle reference AB 639. If one studies JXMX and tries to answer the question, what is it doing? Is it protecting the integrity of the process? I think the answer to that is a positive. Yes, it is, because it is avoiding discrimination in a process which is effectively private business conducted in open court, where CPR 2110 requires the protected person to have the court approve that the settlement, for example, or the interim payment, is in the best interests of the vulnerable person. So, separate point, really, again, trying to keep it relatively succinct. The inherent equitable jurisdiction can be used, equitable jurisdiction can be used to protect confidence and Article 8 rights. So this is I've used the word equitable to try and move away from simply protecting its own process. This is a different source of power. But in that circumstance, our submission is there's no need for separate proceedings, a la Abbasi, paragraph 98, because one wants a practical and effective solution. And PQ, which you've got at Authorities Bundle 849, is an example of the court making an order within proceedings which are before the approval stage. And the relevant paragraphs within that, just to understand the issue properly, is paragraph 3, where Mr. Weir's submissions from JXMX are reproduced. And the only one of the three, this is Authorities Bundle, page 850.
Could you give me the tab number, please? Thank you.
24,
right, whatever.
Yeah, I'm just looking
4.24.
4.24,
Yeah.
I'm very
And
grateful.
the page number was
850.
850, thank you.
Just three paragraphs really from this judgment. Identifies the rationale for the approach in JXMX, court's function being protective and fundamentally different from normal function resolving disputes, publication of highly personal information about claimant's medical condition, serious invasion of privacy, and 3, unlike adult litigants, a full capacity of free, the children and protected parties, etc., no discrimination. And rules out 1 and 3 and says at paragraph 6, the second reason, namely the publication of highly personal information about claimant's medical condition, does apply and would certainly be involved to some extent in these proceedings, even though they're liability. They still involve a serious invasion, and there's a collision between the interests of the child and the interests of the press, and there's analysis. And at 9, the evaluation of the approach, the dichotomy described between the principle of open justice fully satisfied by there being no anonymity order at the liability stage is then more severely restricted at the approval stage because of jigsaw effect, which may well mean that settlement, etc., can't be reported. Middle of the paragraph, in my judgment, no black and white answer. The question is whether the criterion of necessity is more satisfied by anonymity throughout, thereby preserving the ability of the press to report in full the proceedings. And this picks up on a point raised by your Lordship's full consideration is what's in a name point. And the point that comes out of this judgment indeed is reflected in one of the cases referred to, I don't need to turn it up, is that you have this balance between you can actually report more if you take the name out than you would be able to otherwise. Undoubtedly, in the circumstances, it had to be necessary for anonymisation, that the limited derogation. Our practical point is that should be a power that is open to the court without very substantial additional evidence being adduced by any party. The practical reality in these cases, both at approval and probably at this stage, is the court will already have before it a good deal of evidence. In a typical approval case, you will always have a report from the deputy, you will have a report from the various experts, including psychologists and so on. All the evidence there to make good your vulnerability or not is there. And from the defendant's point of view, we were anxious at the seeming requirement that each application, whether it be in the approval process or in this pre-approval process, would have to be attended to by additional cost, which ultimately would be borne by the defendant, in circumstances where that balance can be made under an inherent power. That was one of our concerns, and we say there's nothing wrong with PQ.
Can I ask this? We all know what Scott and Scott said about open justice and things that are painful, embarrassing, humiliating, and all the rest of it. That's House of Lords authority, which no one has yet said is wrong. No. If the sole basis for an anonymity order at this stage in ordinary civil proceedings is the one identified by Mr. Justice Martin Spencer, that seems to be directly in conflict with high authority. And that I have a bit of a problem with that, because it has the potential for enormous ramifications, because as we all know, in all varieties of civil and criminal litigation, all sorts of private, personal, wounding, intimidating, harassing, medical, sexual, personal information, financial information, all these things come out. So this has the potential to be the thin end of a huge wedge. So that's one point. Is another possible justification for the approach adopted by Mr. Justice Martin Spencer the need to preserve the right identified in the Dartford case for this narrow, relatively narrow category of claimant to have anonymity at what is, on the evidence, overwhelmingly likely to be an approval hearing. In the majority of cases, that's the end point of the litigation. So protection of that right, whether it's characterised as procedural or substantive, could be an alternative justification for anonymity at the earlier stage. So not an equitable basis, but the preservation
of
the integrity
prospective approval process. And I should say, my lord, that is an approach I think in my initial submissions I was attracted by, and I think I still stand by, which is that if you have an eye to the ultimate approval, or the likely approval, it won't necessarily, there could be a contested trial on quantum, it's not necessarily going to end up but the court could prospectively, protecting its own process in the PQ way, justify it as not as pure confidence-based, but a protection of its own integrity of its processes to preserve the anonymity ability at the culmination of the hearing.
And in the process, avoid the discrimination, which was the foundation of Mr. Boyer's submission.
Indeed.
In the Dartford case.
Indeed. I mean, so my submission is that would justify, and as I tried to say, I'm keen to preserve the practical and effective and consistent approach which has been adopted to date, both in respect of JXMX and even anonymity as pre the approval process, this approach. Very briefly then, a few final points. I'm sorry if I've taken longer than I initially anticipated. Our position on 39.4 is it's a procedural rule that doesn't create a power, but I'm not sure if that's now central to the appeal. In terms of Mr. Justice Nicklin's reasons, again, I just mention, again, see core bundle page 272, which is those additional reasons provided on receipt of the Commission to Appeal application. Just 2 points really from that document. The first is that at FB, once again, it's absolutely clear how concerned he was about Jigsaw, and that was one of his main concerns about the effect of pre-publicity, and that was material to
So which paragraph?
FB. And that chimes with a passage I've already referred you to, paragraph 59 of the full judgment. We say he was right to say at B that a failed application for anonymity order, so if you would result in a cost follow the event order, the usual position as a defendant will be neutral. And the point that our only point really here is, if the complexity of the application is caused by the how and when the application is made, or prior publicity, meaning a far more complicated application is made, or it's in this case, the application is made on the basis of protecting confidence, which prompted the reasoning given, then that would be a failed application with normal cost consequences. And ultimately, not to repeat myself, I hope too much, in terms of any guidance that this court may make, I'm leaving it to the court as to what nomenclature to give to anonymity orders or non-disclosure orders. But we maintain the point that the distinction between a withholding order and RO is a proper one, but an anonymity order usually encompasses both. That JXMX has worked well and should continue to be allowed to work well at relatively low cost, and that PQ again is an approach that can be justified. We don't endorse a wholesale change, that is to say that we should transfer court of protection processes to civil litigation or this kind of civil litigation, and we don't think it's necessary. And just to emphasise, I've said it already, but the importance of consistency in answer to the concern raised by Mr. Justice Nicklin that JXMX appears to be consistent with appellate authority. My real answer to that is, firstly, properly understood it's not, and secondly, insofar as there is a conflict, consistency is a trump which should ensure that this process continues to be capable of being operated. Otherwise, the court will be effectively clogged up with complex applications, incurring a substantial amount of additional costs, which won't just incur us as an individual defendant with more exposure to costs, but all such bodies who face such applications, which is, as has been said all along, we were neutral, and it is usual to be neutral on such application. My Lord, those are the only points I want to make.
Can I just ask, can I, just to clarify, please, accepting your neutrality in front of this court, as I have heard your submissions, seems to me that you're with the appellant on the jurisdictional basis for an RRO. You accept or you agree that there is a common law inherent jurisdiction to make an RRO in these sorts of circumstances.
I do agree, although the precise delimitation of where one crosses the line between that and equitable jurisdiction, I don't choose to.
There may be differences on that, but it must follow from that, therefore, that you join the appellant in saying that Mr. Justice Nicklin was wrong, erred in law, where he talked about the jurisdiction for making an RRO, paragraphs 51 to 53. You accept that your case is that he went wrong there?
I consider that there is an error, that there is jurisdiction.
There is jurisdiction. And you say that Dartford, broadly speaking, was correctly decided for the reasons given and should stand. We can talk about PQ separately. So in the big picture, there's not much between you and the appellant, is there, in this case?
Well, we were neutral on the application.
Yeah.
I think what there is in terms of how the balancing exercise is actually carried out in court in respect of the
on
order
the facts
sought.
of this case.
And on that, it's not. I'm not making submissions either way, but it's quite clear how Mr. Justice Nicklin approached it and what he thought of the balance between, and that there wasn't much really. It was a very weak case. He thought.
Yeah, but you'd accept, I think, that if he went wrong in law, which you say he did, it would be for this court to remake or remit. So we would consider.
I accept that.
Yeah. Okay. Thank you very much.
Thank you.
Thank you very much.
Yeah.
Yes. Good morning.
My lord and my lady, the official solicitor, as an intervener on this appeal, takes a neutral stance in relation to the facts underpinning the appeal, but wishes, in the interest of assisting the court, to make suggestions about how this court may provide guidance in the judgment which follows upon this hearing. Firstly, in relation to 2 points. As Mr. Hyam has forewarned you, the official solicitor's primary position, and I appreciate it may be using your lordship's terminology, an adventurous one, suggests that the practice in the court of protection may afford and offer a very practical and neat solution to parties facing the circumstances faced by the parties in this case. But if the court considers that that is a step too far, the official solicitor would encourage this court to give guidance in the judgment about the type of evidence that would be necessary to adduce on behalf of a claimant or protected party in order to secure an anonymity order, and for the avoidance of doubt for the court, because I too have been a little thrown in the reading in. When I say anonymity order, I am talking about a withholding order and a reporting restrictions order. But in order to give that submission a little context, my lord, I should be grateful if I could pick up on where my learned friend Mr. Weir touched in his submissions towards the end of the afternoon, which is the practical realities that are often faced by protected parties. And in particular, in response to my Lord Justice Warby's question, that the appointment of a deputy is not necessarily a panacea to all problems or challenges that may be faced. I wonder if I could ask the court to turn up the official solicitor's witness statements that are in the core bundle both dated the 6th of February, and they start at page 121 of the open core bundle. Now, in summary, what I'm going to say, and it's echoed in submissions, is that the appointment of a deputy, as I've just indicated, does not answer all questions about potential vulnerability and exploitation. And that is for several reasons, the first of which is that an appointment of a deputy only is mandatory if the damages or the settlement is £100,000 or more. But secondly, as my learned friend Mr. Weir indicated yesterday, the costs involved in a deputyship are substantial, and therefore the deputy would rarely be involved in day-to-day policing of a pot of damages or funds. And as you will have seen, if you've had an opportunity to look at the examples given in the table appended to the official solicitor's second witness statement at SC3, I'll give you a page reference. The risk of exploitation can often...
Where's the page reference?
I beg your pardon, my lord.
It's 149.
Yes, it's 149.
Thank you very much.
And if the court turns over to pages 153 and through 154 and 155, you will see that the risk of exploitation can arise in relation to relatively small sums of money that may be made available to a protected party. But just drawing back for a moment, the two big points that arise on this are, first of all, the fact that, as my Lord Justice Warby has alluded to and was alighted upon in the Court of Appeal, Lord Justice Warwick's judgment in JX, the real issue here is ensuring that there isn't discrimination against this relatively small cohort of people who are protected parties, and therefore that their Article 814 rights are not infringed. And this is why the issue of anonymity becomes so key. As my learned friends have indicated, and this is the experience of the official solicitor, the practice following the Court of Appeal's decision or judgment in JX has been consistent for 10 years and was regarded as working very well because it provided consistency to parties. The difficulty with the judgment below, comprehensive though it is that it leaves the impression to the professions that unless an order is obtained, an anonymity order is obtained at the outset of proceedings, the ship has sailed. And the concerns for the official solicitor are several-fold, because as she's indicated in her second witness statement, and I've alluded to in my submissions, the difficulty is that although admittedly this is a relatively small group of people, by this group of people I mean protected parties, they are a diverse group. And therefore the circumstances in which they bring proceedings is very varied. The official solicitor, just to be clear, is often not appointed at the outset of proceedings. The protected party may be represented by a litigation friend who's a family member, or may even start the proceedings themselves. What must be remembered here is that the fact that somebody lacks litigation capacity does not mean that they are in any other way somebody who lives a relatively ordinary, high-functioning life in the community. Capacity may be lost during the course of proceedings if somebody has a condition such as a personality disorder that may result in fluctuating capacity, or as is quite frequently the case with brain-injured claimants, the fact that the protected party actually lacks capacity may not be apparent at the outset of proceedings. So the difficulty with finding consistency with this group of people, or this cohort of people, is that they are diverse and the circumstances in which they end up engaging in litigation is very, very varied. But what they all have in common is their vulnerability. Now, if I could ask the court to turn back to the table at SE3, starting at page 149, I would suggest that this gives a series of examples which illustrate vividly the risks to which this group or cohort of people may find themselves subject. Now, first of all, just dealing with my Lord Justice Warby's point, yes, of course, like all claimants, they face the risk of details of their lives being placed into the public domain, which may be distressing. But in this particular group, particularly the examples you'll see of claims brought against local authorities for historic abuse, those details may extend into information which they themselves were previously unaware. And its discovery may be inherently distressing. So there is a risk that is multiple-fold and is very difficult to predict at the start of the proceedings, which is not only of financial exploitation, if the fact that the protected party is a claimant in damages proceedings goes into the public domain, but also the risk to their own psychological welfare if information which by virtue of their incapacity or their disability they were previously unaware becomes known to them. The other issue here that is worth bearing in mind, it is not touched upon directly in the official solicitor's evidence, but that one cannot preclude that the possibility that a protected party will be able to read press reports or social media reports about themselves independently of the care staff, whoever is looking after them. So, in short, the point is that this is an inherently vulnerable group of people. They bring proceedings usually with a litigation friend, obviously, or a litigation friend is appointed during the course of the proceedings. Therefore, the decisions about the litigation are not made by them themselves, but on their behalves. The process of obtaining the appointment of the litigation friend often involves disclosure of information about their ability to function cognitively and intellectually, which is inherently private, and they are often vulnerable by virtue of the circumstances in which they are living, or they come to become a protected party. Just concluding on that introductory point, an application for anonymity often is not made at the start of proceedings, not through inactivity or any carelessness on behalf of those who are protecting them, but simply because the need for it and the status of the person as a protected party is not always necessarily clear at the outset. It can be capacity can be a moving picture.
Can I just ask this? I mean,
Yes.
if in those cases where it is clear,
Yes.
is there any obstacle or reason not to get on with it?
Well, this comes to the point, my second point, which is that the official solicitor would welcome guidance being inserted into or incorporated into the court's judgment about what evidence would be necessary or what would have to be placed before the court at the outset of the proceedings if the court is not minded to adopt the processes in the court of protection. This is because, as my learned friend Mr. Weir alluded to yesterday, the difficulty is, at the outset of the proceedings, the risk to the protected party may not actually be apparent. As my lord, the Lord Master of the Rolls, put it, the bad actor may not yet be upon the scene. So there is the fact that the risk may not be apparent, and even if it is apparent, it may be that actually obtaining direct evidence of the nature of the risk may be extremely challenging. Remember, if you're dealing with somebody who lacks capacity, it may be that they do not have insight into the fact that they are at risk of exploitation. The motives...
Well, I mean, you say, do you not, that Dartford was correct in saying that in this very specific class of case, generic evidence is not only appropriate, but sufficient.
Yes.
And it's appropriate and sufficient, you say, because there are multiple diverse factors affecting vulnerability which cannot be predicted, even in a specific case.
Yes.
And all specific evidence would be guessing as to what might happen in the future. And it is the very situation faced by a protected party with severe injuries that gives rise to the need for these kinds of order.
Twice.
But where is the line? Because I balked at there being a vast number of these cases only because I was thinking of very serious clinical negligence cases where very serious injuries, not life-threatening, but very serious life-affecting injuries are sustained at a young age. I don't have a clear idea as to the range. So do you say that Dartford applies to any clinical negligence claim brought by a protected party, even, if I'm being trivial about it, somebody who's got a painful finger for life, which, we all have to live with some inconveniences, or where is the line?
The line, I would suggest, is that it must be, if I may start again, my lord, it is almost impossible to define a line, and that is why the practice in the Court of Protection may commend itself to this court, because the default position is that the transparency order or the contra mundum injunction is granted at the outset of the proceedings by the judge in chambers, but is then reviewed at every subsequent hearing, so that an injunction is in place, but then those representing the protected party are expected to justify its continuation or its continuation in that form. And many of them are actually substantially amended and the cover reduced as the proceedings continue. But it has the practical appeal, and I appreciate that this is a very practical solution that has been alighted upon by the division in the Court of Protection. The practical appeal is that the protection is in place until such time as the court and the parties have an opportunity to draw breath and address the balancing exercise of the various interests and rights and whether the order should continue or continue in its initial form. But the difficulty of taking my Lord Master of the Rolls example of the protected party with a painful finger, assuming it's been occasioned by something such as a fracture. That protected party, if the litigation is successful, will still obtain an award of damages, in all likelihood, either through an extrajudicial settlement, which will need to be approved, or if proceedings are issued possibly after a trial. The sum of money may be relatively modest, but that does not mean that the the protected party is in many ways at any less of a risk of exploitation than his counterpart, who's unfortunate enough to suffer a severe brain injury and therefore attracts a much more significant sum. The other issue, which has been touched upon by my learned friend, Mr. Weir, is that the socioeconomic circumstances of this cohort of people are equally diverse as their disabilities, and therefore, although sums concerned may seem modest, that does not preclude the possibility, or in some cases likelihood, that they will attract the attention, to use my Lord Master of the Rolls' words, a bad actor.
But it's a bit counterintuitive, I think, in this court to say that it is necessary to derogate from the principle of open justice so as not to record that a child has suffered a medical negligence incident that gave rise to damages of £5,000 for a bad finger.
Well, my lord, doesn't it come back to paragraph 41 of AVBBC and Lord Reed's comments at the end of that paragraph, that the issue on each case must be the value of the information concerned in terms of looking at the public or satisfying the public interest.
Sorry, I think I'm going to have to look at it again.
Yes. It's a page 615, behind tab 415. And at the end of that paragraph, concludes with the sentence, central to the court's evaluation will be the purpose of the open justice principle, the potential value of the information in question in advancing that purpose, and conversely, any risk of harm which its disclosure may cause to the maintenance of an effective judicial process or the legitimate interests of others. The legitimate interests of others here being their right to privacy. So, yes, my Lord Master of the Rolls' example of the child with the sore finger or the fractured finger is right at the bottom of the scale of seriousness. But that does not detract from the fact that the issue is whether the derogation from open justice, in this case, the suggested withholding of the name protected with injunctive relief, is actually, first of all, a derogation such that the open justice is going to be significantly encroached upon. One would suggest, for the reasons that have been addressed and in submissions by my learned friends, the answer to that question is no. The issue is often the underlying facts of the case and the court's decisions arriving from those facts rather than the name, but also what value the child's name actually serves in open justice. Now, if I may just set the Court of Proceedings the Court of Protection Proceedings approach in a context, the review of the contramundum injunction prohibiting the identification of the claimant or the applicant usually takes place within a matter of days after the order being made. So it is very much a holding the ring.
Well, that's the practicality. But you're suggesting that the principle is, what's the point of naming this person? We can find out everything we need to know about the case without the name, because that serves the open justice principle. But isn't a fundamental part of open justice ensuring that the public has confidence in the system, and secrecy about anything to do with the case is liable to eat away at confidence in the system?
Well, it's a question of gradation, isn't it? I mean, the problem is, as my Lord Justice Warby alluded to yesterday, it is very difficult to examine these issues and arrive at firm conclusions when one is trying to consider circumstances without the specific circumstances of an individual case before it.
But if it's just, well, this person's private life interests are important, and this individual name doesn't really help the public understand what went on, we would have a revolution in the approach to justice in our system, because that's typical of many, many cases.
It may be typical of many cases, but what I'm inviting the court to conclude is that this is the cohort of people that we are dealing with when considering protected parties are not a typical group. They have enhanced vulnerability. Therefore, the balancing of the Article 810 interests is different from that of a claimant with capacity or a party with capacity. Not least because in those circumstances, the individual has brought the proceedings or become a defendant in proceedings cognizant of what is going to happen. When you're dealing with a protected party, those decisions and the risks that are associated with them have been made on their behalf by a third party.
Ms. Patterson, I don't think you're saying, are you, that in a broken finger case, the court must necessarily grant anonymity if requested on the basis of generic evidence, because it would always be for the court to be satisfied that the necessity test was met, and the court may or may not be. Aren't what you're really saying is there might be cases, even in that low value, end of the scale world, even though you might find some cases where you needed anonymity because it would all depend on the facts. But is it not reasonable to think that in the real world there are some smaller cases where either the litigation friend and solicitors and everybody else would agree that anonymity simply wasn't warranted because there was so little in the case to excite the public interest or to be worth protecting?
Yes.
Alternatively, there might well be cases where an application is made, but the judge might quite justifiably say, on the evidence before me, I'm just not satisfied that this is necessary.
Yes, exactly so. The issue, and this is why I use the term holding the ring, and I have been stressing...
Well, that's your court of protection alternative model. Okay.
Yes,
yeah.
And I have been stressing that in the court of protection alternative model, the review at which the decision which my ladyship has just alluded to would be taken very early in the proceedings, so that if the case appeared to be one in which it was not really necessary for the protection of the protected party's private life, that the anonymity continued, that decision would be reached early in the proceedings and the order discharged.
Well, I think we understand the principle. The difficulty, speaking for myself with that, is that it involves an order being made at the outset in circumstances where no judicial mind has been addressed to necessity or otherwise of making the restriction order. There's another more practical issue, which is that we have a lot of backlogs in civil at the moment. It's not that easy to get before a judge to have a look at whether the order is a sensible one to make.
Well, backlog, I would hope, would be met by the fact that, as I've indicated in my submissions, the decision taken by the Court of Protection judge early on when these orders are made is very much on a summary basis, as directions appointing the official solicitor and setting the case down procedurally for a final hearing, and any orders of disclosure or witness statements, expert evidence are made. So it is part and parcel of the court's standard case management, which has got to be undertaken anyway. I appreciate that the procedure is going to be quite different in the Court of Protection from, say, that of a clinical negligence claim in the King's Bench Division. But the natural review for the order in the King's Bench Division, using the facts and the procedure of a clinical negligence claim, would arise at the very latest at the approval hearing, if not before at the case management hearing before the master. So although there is not a direct parallel in the procedure and the opportunities afforded for the order to be reviewed, there are certain parallels which mean that this is something that the official solicitor considers that it's been appropriate to raise with the court. The other fallback position that the official solicitor invites the court to consider in any guidance that is handed down is guidance about the quality of the evidence that would be needed at the outset. And I think my Lord Marshal Rolls has the point that this is already being covered by JX and the use of, if I may use the terms used by the Supreme Court in Abbasi, generic evidence. And the official solicitor would ask that this court endorse that approach for the reasons set out in my submissions and her witness statement, that it is almost impossible at the outset of proceedings, when it is obviously the ideal time for an application to be made, to predict exactly how a risk would eventuate and what the consequent harm might be.
The problem with generic evidence is that the finger case. Dartford doesn't. I was just looking to see whether Dartford addresses the severity of the injury or the circumstances of the case,
No.
and it doesn't, as far as I can see. It simply assumes that because the party is protected and therefore inherently vulnerable, and the vulnerabilities will be common to a range of cases, that the order will be automatically made in most cases,
Yes.
except where it's shown it's not appropriate, where it's not necessary. But since there's nobody to oppose the order, if the rule is as in Dartford, it will always be made. And I think my Lord might say that there is a problem with infringing the really important rule of open justice by rote. And that's where I find difficulty, because if we say, as Dartford says, and maybe we're bound by Dartford, but if we were to say procedurally no evidence is needed, you don't even have to show it's in a category of case that Dartford must have been properly alluding to, we really are doing what the judge objected to, which is driving a bit of a coach and horses through the open justice rule.
The official solicitor isn't advocating an approach by which no evidence is adduced.
No, what are you advocating?
That evidence of a generic nature, namely if you use the example of the child, and the official solicitor is primarily concerned with incapacitated adults, but using your lordship's example of the child, this is the age of this child, these are his or her family circumstances, this is the nature of the injury, the prognosis, these are the, or if there's a schedule of loss, which is unlikely possibly in an example of a finger case, this is the likely value or the anticipated value of the claim. And this is why there could be, this child could be at risk of financial or other exploitation. I'm just a little concerned, my Lord, the greatest of respect, that the example of a child with a fractured finger is a very long way from very many of the people that the official solicitor comes to represent and who are the subject of the concern. As
But the official solicitor doesn't represent children.
Well, only in very specific circumstances. But I would suggest, and I'm not going to...
But I'm not talking about a child with a fracture. Maybe it's a bad example. But I'm talking about less serious injuries and less serious cases. And the question is whether in less serious cases it is axiomatic that there should be such an order. And anyway, speaking only for myself, it seems to me more problematic at that stage. And I also question the word generic for the kind of evidence that you have been talking about. That is not, it may be of a generic kind, but it is actually specific evidence about the case. And again, it seems to me that it is absolutely necessary for there to be evidence about the case before the court before an order is made. I mean, just while I'm talking, I'm resistant to the cop analogy because I just don't think this is an area where there should be automatic orders made. I think they should be considered by the judge, a little bit like my lady said. But the question is, what should the judge have before them? And, you know, I think at the very least the judge has got to have the circumstances of the case and the prognosis and the nature of the injury. Now, if one did that, and I'm not quite sure what Dartford really means, so maybe you can help me with this, but if you did that, then the judge could spot something where derogation was not necessary quite easily.
Yes. But the point is that I think both the appellant and the official solicitor's concern has been that following the judgment below, there could be confusion around the level of detail that was required about the risk that the claimant or the protected party might be at without an order.
Completely get that, and you've made a very clear submission that risk doesn't appear until later in many cases. The bad actor may not be on the scene, the risk of fraud or meddling or psychological damage may not be apparent, and etc., etc. Completely get that. But what I'm saying is that, you know, the risk of psychological damage and people coming on the scene to steal the money is rather less if we're talking about very small claims, and therefore not automatically the case that such an order, which is quite a swinging order, is necessary in every case. So you have to protect against making orders that shouldn't be made in justice, in my view anyway.
My lord, I think it is a dangerous trap to fall into to assume that because the potential damages or settlement sum is modest,
Right.
that the risk of exploitation or abuse is not present. That is why I referred to...
It may be present in a lesser, to a lesser level, and it may be a balancing exercise that has to be conducted.
Yes, but the point, the appeal or the initial practical appeal of the approach in the Court of Protection is that the protection of the vulnerable person is afforded whilst there is an opportunity identified either at a listed hearing or otherwise for the court to draw breath and the parties to make submissions. All of these orders have a liberty to apply.
Of course. But the problem with that is these are not court of protection proceedings. They're not even brought under the parents patriae jurisdiction. They are simply ordinary litigation to recover damages. And they're brought at all different times, in all different ways, for all different reasons. And they result in settlement, mostly approval applications. But even the approval applications, as I understand it, arise at all different times and in all different
Yes.
occasions. And sometimes you've had a trial, and sometimes you haven't had a trial, and sometimes it's the day before the trial that the settlement is reached, and sometimes there's a great deal of posturing, and the posturing may lead to bad actors coming on the scene. So there's all sorts of different situations, and just making an order as of rote, even if there's liberty to apply, because the problem is there's nobody really with an interest to apply.
Unless the order is served on the press or notice is given.
Well, how many orders are we going to serve on the press? I mean, do they want to be deluged with orders, with hundreds of...
We publish them. Anybody, if an order is made, it is always published, I think, isn't it? And
On the
can
website.
then be
Has to
subject,
be.
yeah, and then can be resisted to resumed hearing. Didn't Lord Justice Morbick give us a little bit of help on this? Because he said on
Which
page
paragraph?
639, I'm in paragraph 31, that he'd ultimately been persuaded, so exactly the same arguments must have been articulated in front of him, that although each application will have to be considered individually, in other words, he was absolutely not saying this is a blanket rule. He was saying you look at each one. We know that the test for the judge in each case is one of necessity in the interests of justice. But what he was saying is that the judge can generally assume that there will be future risks for these sorts
Yes.
of individuals. So you don't have to go to town on that. But the rest of it is for the judge's evaluation. And then isn't the answer that the judge either makes the order, which I suppose keeps the claimant happy, but if the press think it's the wrong thing to do, they can apply to
Yes.
dislodge it. But that's on the back of the judge being satisfied as to necessity. But if the judge isn't satisfied, the claimant doesn't get their order, but there's nothing to shut the claimant out from coming back with better evidence, if better evidence there be, to satisfy the judge. I mean, nobody wants that. You don't want repeated applications. No. But isn't that where it lies? That if the judge isn't satisfied on the basis of the evidence that he or she gets, there you are. You have to take your chances again. If there's something the judge has missed, then bring it back.
Yes, and this would happen, and I'm sorry to bang on, but this would happen at the first directions hearing in the Court of Protection. And counsel are frequently asked to justify the continuation of the transparency order that's been made in chambers. So this is not, what is being suggested here is, and again I stress this, is an exercise that is practical in holding the ring, maybe only for a matter of days or weeks, while the press, as my Lady Justice Whipple has alluded to, are on notice of the order having been made, having been published, and thereby their right to apply for it to be discharged or amended. So the Article 10 rights are, at least in measure, to a degree, protected. If I may adopt the submission of my learned friend Mr. Hyam, and I think Mr. Weir, the official solicitor considers that JX is the correct approach, and that it has in fact worked very well since 2015 when the judgment was handed down. The concern that is left by the judgment below is that it suggests a departure from JX, but also critically that if an application is not made at the outset of proceedings, then the opportunity has been lost. And for the reasons that are set out in the statement and the submissions filed on behalf of the official solicitor, it is submitted that that is inherently unfair, particularly for this cohort of people.
Yes.
My Lord, I am very aware of not detaining the court unduly, but could I just, before I sit down, because I think you have my 2 points, and I sense that the adoption of the practices in the Court of Protection...
Not going as well as you might have liked.
Well, I sense that it's being received with a degree of scepticism and cast in the role of the adventurous approach, using my Lord Master of the Rolls' kindly words in relation to the judgment below.
Yes.
But I do consider that it is, with the greatest of respect, important that the judgment of this court is grounded in the realities that are faced by this cohort of people, and with the greatest of respect to the judge below, his comments about the risk to PMC being negligible suggests that perhaps he didn't have the benefit of the evidence before him that would have assisted him in understanding the real risks faced by this cohort of people, the fact that they are at risk of finding that their Article 814 rights are infringed, and thereby their access to remedies through the court process is vastly reduced. But if I can just take, my Lord, the court, I should say, to the key passages in the official solicitor's evidence.
Which was put in at this court, was it? This level?
Yes, I'm absolutely clear the judge below did not have the benefit of any of this.
Yes.
was
Can we
work-
see the key passages? That's
Yes.
going to be very helpful.
Starting firstly with the table at 149, which consists of 14 examples taken by the official solicitor from both within her office and from 3 firms of external solicitors whom she instructs. Particularly at 149, 150, 151 and 152 and 153. Now, I'm not going to read out the details that are contained in the table, lest the purpose of having the text redacted from the copies which appear in the core bundle be utterly defeated, because there is a risk that an informed listener on the link could identify the individuals concerned.
Well, we can read these for
Yes,
ourselves. And
yes.
We'll do it. Yes.
In terms of the body of the statement, I would invite the court to consider the types of litigants described at 126 and 127, the risks that are set out at paragraph 17, which runs over 129 and 130, and then
Sorry, let's just find it. The subject matter of the litigation also give rise
Yes.
to different considerations.
Yes.
Sorry, what was the page there?
it's 129.
Thank you very much.
This is the continuous text that sets the scene for the 14 examples in the table that I've just taken the court to. And then the official solicitor's comments at paragraph 20 at 131 about the timing of the application for anonymity. Paragraph 133, paragraph 24, 5, 26 and 7 deals with the evidence and the challenges which a protected party may meet in trying to gather evidence to meet the test of necessity, and in particular the term used throughout the authorities of clear and cogent.
They can't reach that. I mean, the problem is there seems to me to be a clear distinction between putting the facts of the case before the court, which to my mind anyway, speaking only for myself, is really unavoidable if you're asking for an order of this importance, and saying this is the circumstance, this is what happens, this is the claim, this is the person's family circumstances, this is the person's injury, and so far as possible the prognosis, which may not be possible,
No.
but some information about where things stand on the one hand, and evidence on the other of particular risks that may be faced. Because once you've explained the first bits of evidence, the risks may, as Lord Justice Moore-Bick seemed to imply, be generic. They may be the kind of risks that people in that situation face. So if you're talking about the danger or difficulty of not being able to put the basic facts before the court, I'm afraid I would be resistant. But if you're talking about not having to spell out whether the risk is from the grandmother or the...
It's the latter, my lord.
Yeah. I mean to say in evidence the risk is from the grandmother because I don't like her, and not from the grandfather because I do like him, could turn out to be, first of all, very damaging to everybody in the case, and secondly, utterly untrue. I mean, it's just nobody knows.
Well, quite so.
Yeah.
And it's also highly speculative, because if one takes an example of a brain-injured person who requires 24-hour support and care, it is inevitable that there are going to be a vast number of different actors in their life,
Yes.
keeping them fed and watered and
They'll
looking after them.
change. They'll
Yes,
change.
and they will change over the course of time. So the picture is moving. Also, as the person ages, the risks will change.
Can I just ask this? I absolutely take your point, and for my part, I agree with the Master of the Rolls' approach to the two categories of evidence that he's identified. One of the issues we had to deal with in the case of Sharif earlier this year was whether anonymity is the solution to the problem. And it would be helpful if you could just encapsulate, or perhaps give us the references to the bits in the evidence which explain why that is. I ask this because, as you pointed out, the most danger seems to come from people who you would expect would be aware anyway of who the person was and, in broad terms, how much money they'd got. So, just help me to understand how anonymity helps.
Well, it's a combination of not just pure anonymity, my lord, but the fact that the protected party cannot be identified as a claimant in proceedings for damages. So that if you take the example of say a 17-year-old with limited cognitive functions who is attending a college but is involved in proceedings following a road traffic accident, a newspaper report could report that they go to a college, X goes to this college, whatever, and publish a photograph of the college's open day in which X appears. The issue is that X is not identified as a claimant in proceedings.
No, that's Section 11. That's all that Section 11
yes.
Confers is a power to prohibit the identification or whatever other matter it is in connection with the proceedings. So yes, it doesn't impinge on anything else. But that's my point. What you're seeking to avoid is the risk of exploitation by someone who knows that in proceedings for damages this person has recovered a substantial amount, or an amount that interests the bad
yes.
actor, whatever it is. On this hypothesis, the facts of the proceedings and that there's a claim and the amount of money all gets published, and the person who's close to the individual will probably know quite a lot about the circumstances anyway. And
Well,
put the two and two together. That's the jigsaw identification.
Well, this is why, and I tentatively go back to the corporate protection and by way of an example, but it's often why an injunction in the court of protection doesn't just refer to P being a party in proceedings, but may be extended to P living, say, in a particular part of London, or attending a particular clinic for treatment. These details that would enable, or such details that would enable somebody who knows P, if they were reading about them in the Daily Mail, to say, that's the person I see every day going into that college or going to that clinic. So anonymity is the starting point, but dependent on the circumstances of the case, the order may need to be broader.
As the order sought in this case was and remains.
Yes.
Anything that would lead to their identification.
Yes, yes.
Formula. Thank you.
I mean, there is a tension between that kind of order and the name of a person already being in the public domain.
Is my lord envisaging a situation whereby the name, the anonymity order not having been made, the person's name has appeared on the lists, or?
Well, I mean, the list I find slightly less compelling, but having appeared in the newspaper as having suffered this kind of injury because of the negligence of a particular authority is a bit more serious.
Well, I'm very wary of not treading on or trespassing out of my role as intervening into sort of co-appellant counsel. But I think it depends very much on the individual facts. Of course, it is much better if the application for the anonymity order is made and granted at the outset of proceedings. But the official solicitor is equally keen to ensure that this judgment, insofar as it is able, makes clear that if it is not made and granted at the outset of the proceedings, and there may be some press reporting, that the door is not closed to a protected party, obtaining an anonymity order subsequently. I mean, one need only look at the judgment of the House of Lords in PJS to see that even on the facts of that case, where there was a significant amount of material about PJS and his affairs published already in the internet and some in paper print, but despite
the first paragraph of Lord Mance's judgment is marvellous.
Well,
Yes.
I would say yes. Right, so
But,
I can't improve.
Anyway, we're bound by it. But
Yes.
no, my point really is that if you're trying to have a one-size-fits-all approach, you do
Pro
need...
tem. Oh, right at the outset of the proceedings, my lord.
Well, I know that's your case,
Yeah.
but assuming that's not possible, and you're trying to have a one-size-fits-all set of guidance that applies to all types of case, large and small, cases where there's been publicity, in cases where there hasn't been publicity, in cases where no proceedings are issued until very late on, in cases where proceedings are issued very early on. You do need to be careful to keep an eye on what is necessary, because what is necessary is very much a value judgment based on the facts. And so what I'm slightly concerned, I think my lady pointed out to me in paragraph 32 or whatever it was of Dartford, which I think does address this question. But it's, and you know, Lord Justice Morbick was obviously very, very careful to say in every paragraph, it must be necessary, it must be necessary, it must be necessary. But he wasn't considering the jurisdictional question that we have to consider. And I'm just concerned that if we lay down that the devil is in the detail, that, you know, Mr. Weir has changed his ask, maybe astutely in order to get what he wants, but actually we have to consider the generality, how the guidance we give will apply in a general case. And the pre-existing publicity is really complex, actually, to the kind of order you might be making in the future. So if we say things that seek to be applicable to too many kinds of case, because Dartford was only considering approvals.
Yes.
I mean, that's the problem, and this case is not. We haven't even gotten approval yet in this case. Anyway, I mean, I think you get the point. I think it's actually a very tricky area of the case. We're going to have to tread carefully.
It is very tricky, but as my Lord Master of Rolls has alluded to this morning, the issue is about, or the jurisdictional basis is the inherent jurisdiction, the court's inherent jurisdiction to protect the integrity of its own procedures. And the problem is, looking at that devoid of a set of particular facts is extremely difficult. But I would tentatively suggest that as long as your Lordship's judgment makes clear, or this court's judgment makes clear, that as long as if the application for anonymity is not made at the outset of the proceedings, that does not mean that the chance is lost.
Yes, well, I get that.
Yes.
Yeah.
My Lord, I'm aware I've already detained the court for some time.
Okay.
Unless I can assist the court further, I would propose to close there.
No. Thank you, Ms. Patterson. Who's next? Yes.
My lords, my lady, we are of course very grateful to the court for allowing PIBA to intervene in this appeal. The court will hopefully have discerned the broad thrust of our position from our written submissions, which you can find in tab 1.12 of the core bundle, page 181. Essentially, through our intervention, we seek to tackle a narrow, but as we see it, very important issue, namely whether, putting to one side issues of jurisdiction, the Court's criticisms of the Court of Appeal's judgment in Dartford are fair and legally sound. The criticisms in question are embraced particularly in paragraphs 108 to 114 of the judgment that start at page 305. We say that on a proper analysis, and with all due respect to the judge, the criticisms he made of Dartford are unfair and unsound, and that in its essentials the judgment in Dartford remains good law, although, as you will hopefully have seen from paragraph 27 of our submissions, we do propose a number of refinements to the approach that was approved in Dartford. I pause there to make two important preliminary points concerning our intervention. First, as will hopefully be clear to the Court of Appeal, we do not seek to descend into the arena on the thorny jurisdictional issues which the judgment below has brought to the fore. As we see it, that is an issue which is already extensively addressed by the other parties. And put shortly, we decided to put our energies into a rather different, but we say nonetheless also very important issue, namely, assuming there is jurisdiction, how should the Article 8, Article 10 balancing exercise be undertaken specifically where an anonymity application, we'll come on to talk about what that means in a moment, but where an anonymity application has been made specifically in respect of approval proceedings conducted under CPR 21.10, because of course that was the subject matter of the Dartford judgment. And that's what I'm going to refer to in my submissions as the Dartford issue. I think it's fair to say that it is PBA that has really taken the lead on that issue in this appeal.
So you're concentrating on Article 8, Article 10, which nobody else has mentioned, and Re-S. But as I understand it, everybody else accepts that the jurisdiction in question that we're talking about is the jurisdiction of the court to derogate from the common law principle of open justice, which can be done in order to protect the integrity of the proceedings, both by the grant of anonymity and by the making of the reporting restrictions order to protect the integrity of the proceedings, where such an order is necessary. Now, obviously the necessary bit involves a balancing of the open justice principle against the necessity of protecting Article 8 rights. But why, I mean, I think Lord Reid told us that Article 8 and Article 10, the word necessary, which is found in Article 10.2, is to be construed in the same way in Article 10.2. I'll be corrected by somebody if I'm wrong. Article 10.2 is to be construed in the same way as the idea of necessary in the rule that I've described.
Yes.
How much time does that take to consider?
Well, as I'm going to come on to submit, it's not simply, when I talk about the balancing exercise, it's not simply a context between Article 8 and Article 10. I should have been clear about that, because as we see it, it is also about safeguarding the protective jurisdiction that the court is exercising when it's dealing with an approvals process under CPR 21.10. I was planning to come on to that.
But that's not this case.
Well, this leads me to the second preliminary point I was planning to make in respect of my submissions and our intervention, which is that we're conscious that the court may be asking itself, why does it need to address the Dartford issue at all in this case? Because, of course, the Dartford issue was not the issue that was...
But the reason why we have to address the Dartford issue is because the Dartford pro forma has been taken to apply to all clinical negligence actions when they are initiated by parties of this kind.
Yes.
Has it not?
Well, our position is that is obviously a question the court has to grapple with. How widely should the Dartford principles be applied, and should they be applied outside of the approvals
But in practice,
process?
that's what's happened.
Yes, and I understand that is indeed what's happened, and that's what's given rise, in effect, to the concerns that Mr. Justice Nicklin has outlined in his judgment. But we are concerned with the Dartford issue as it was addressed by the Court of Appeal in Dartford, namely how privacy applications fall to be addressed when they are made specifically in respect of approvals proceedings. And as for the question as to why we invite you to address that issue, bearing in mind that the court's criticisms below were effectively given on an obiter basis, well, we've set out the reasons why we sought to intervene on that issue in our written submissions.
Which paragraph? Which page?
So this is in our submissions, which start at tab 1.13 at page 181. And what we sought to highlight in the submissions, although it may take me a moment to find the relevant paragraph, is that unfortunately the court's obiter comments in this case about the Dartford issue has set the cat amongst the pigeons in terms of disrupting the approach which courts up and down the land have been applying for the past decade in respect of approvals proceedings in the wake of the Dartford judgment.
But didn't my judgment earlier in the year help take the cat out of the pigeons for a while?
Well, the problem is courts and PIBA members and their clients are still left with this question of who's right. Is Mr. Justice Nicklin right?
Well, of course we've got to decide if Mr. Justice Nicklin's right now, but for the moment the cat is not in the pigeons. Is that right or not?
Well, the cat is amongst the pigeons because there have been extensive criticisms
But
made
it's
of
sleeping,
the way
at
that...
least.
Sorry?
It's sleeping at least.
Well, in our experience, it's not sleeping, and,
Right.
and the courts are genuinely in difficulties because on the one hand, they've got the Court of Appeal's judgment as to how they should approach these issues, as set out in Dartford, but on the other hand, they've got these extensive criticisms of that approach, saying it doesn't properly respect the open justice principle. And so the difficulty is courts are uncertain as to what to
But
do.
didn't I say, I mean, I understand nobody maybe read what I said, but not only did I say that people should pro tem apply Dartford, but I also said that this should be published and everybody should know that's what we'd said.
Yes, but, well, our position is a number of serious criticisms have been made of the Court of Appeal's judgment
In Dartford. By whom? By Nicklin J.
By Mr. Justice Nicklin.
Yeah.
In quite a long passage in his judgment.
Yeah.
And effectively, we invite this court to grasp the nettle of deciding whether those criticisms are sound, because if they are sound, the approach needs to change. Alternatively, if they're not sound, then there's an endorsement, a contemporary endorsement of the Court of Appeal's judgment in Dartford, and everyone knows where they stand. What we're seeking to achieve is an outcome whereby the current, really very significant uncertainty as to what the correct approach in law is needs to be resolved at the earliest possible opportunity, which is indeed why PIBA has sought to intervene on precisely that issue, notwithstanding the open nature of the comments made by Mr. Justice Nicklin in his judgment.
Yes, okay, thank you.
So having made those preliminary points, I'm keen to move straight on to the judgment in Dartford, which is in the main authorities bundle, tab 4.16, starts at page 626. I'm going to assume the court's familiar with the facts of the Dartford case, which is set out in paragraph 4 of the judgment. Turning then to the essential issue which the Court of Appeal was addressing in Dartford, the issue was how should anonymity applications made on behalf of protected persons, specifically in the context of approvals proceedings, be conducted that are conducted under CPR 21.10, how should those applications in particular be approached? There's an important question, of course, that the court has raised as to what is meant by the term anonymity, as deployed by the Court of Appeal in Dartford. My lady went to what we consider as the critical paragraph, which is paragraph 32, where the court defines how it's using the term anonymity, although we say that paragraph was to be read together with paragraph 2 of the judgment,
Yes.
which is at page 630, where the court refers to a withholding order as we see it, so the more classic concept of anonymisation. What we say in short is that whilst the court perhaps did not use this terminology, ultimately what the court was seeking to achieve was an outcome whereby in effect there was protection for the identity of the protected person in the context of the approvals process across the board, so a withholding order, restricted reporting order and a non-disclosure order, although we accept that's not how the court explicitly framed matters in the judgment. As we see it, it's using the concept of anonymity as shorthand for all of those protected
Can you give me those
orders.
components again? Withholding order, you say.
Withholding order, restricted reporting order,
Yeah.
and a non-disclosure order around which concerns disclosure of court documents under CPR
I see.
5.4. And in case it matters, our position seems to be aligned with where the judge also landed on that issue. See paragraphs 104 to 106 of the judgment.
Sorry, could you just say that again?
Yes. So
What's
as we
the-
see it, the court is using the term anonymity as shorthand for a suite of protective measures aimed at protecting the identity of the protected person in the context of the approvals process across the board. So both the withholding order
Oh, sorry, you're talking about in Dartford.
in Dartford.
Yes, sorry,
because,
yes, I
because
understand.
that term is used and it's obviously given rise to some confusion.
Yeah, no, it's fine. Yeah.
We would very much, of course, welcome this court making clear what the appropriate terminology is, although I will, for convenience, also use the term anonymity as shorthand for those combined orders. The next point I need to address the court on is the particular jurisdiction with which the court was concerned in Dartford, which is the jurisdiction provided for under CPR 21.10. That provision can be found at tab 2.10 of the authorities bundle at page 83. In short, the effect of CPR 21.10(1) is that where a settlement agreement involves a child or a protected party, which is essentially a person lacking capacity, that agreement must be brought before and then approved by the court in order for it to be legally valid and enforceable. In other words, the effect of CPR 21.10 is that there needs to be discrete proceedings to render the relevant agreement valid and enforceable in law, and we submit that those proceedings are essentially separate to, albeit obviously related to, the civil litigation process concerning the protected party. There's been some discussion earlier today about the sort of evidence that needs to be before the court when it's determining an application for anonymity in respect of the approvals process. On that issue, I just invite you to note 21.10(3), which identifies the materials that must be before the court in any approvals process.
I mean, any documents relevant to considerations of liability is absolutely huge.
Yes, indeed. And I mean, the essential point is that the court was earlier expressing the concern that there needs to be, before the court when it's deciding an anonymity application, information as to the nature of the injury claimed and so on. That information has to be before the court in the context of an approvals process pursuant to 21.10(3). Now, there are a number of important aspects.
It does not have to be before the court in an application made either in the course of an ordinary clinic action or by separate Part 8 proceedings preceding.
No, but it is required for the approvals process.
So what do you say? Do you say it ought to be the same for both?
So PIBA is very keen not to go wider than its narrow remit of dealing with the issue of privacy applications made specifically in respect of approvals proceedings.
But that's not this
That's
case.
not this case.
Well, I come back to my point. I accept that's not this case and that our position seeks to address the court's obiter comments about a different case, which is the Dartford case. And I've explained why we say it's important for this court to give guidance effectively as to whether the court's criticism of the approach taken by the Court of Appeal to the issue that was before it, whether those criticisms are well-founded or not. I accept, I want to be absolutely explicit about this, I accept these aren't the facts of the case that's before the court. But we seek, in effect, to use this case as an opportunity to address the question of whether Mr. Justice Nicklin was right on the criticisms he made of Dartford.
I mean, I'm puzzled why you're so concerned to limit your intervention. And when I allowed you to intervene, I don't remember that being the case, but maybe I was just forgetting. Because PIBA members are surely as much concerned with cases involving ordinary applications in a clinical negligence setting as they are in the approvals process. I mean, we've been told that most cases end in an approvals process, but the anonymity orders are surely made long before in some cases. So, and I mean, the other thing is that it's your members, effectively, that have given effect to extending Dartford into the world at large. I mean, we haven't been shown P something 10, but I don't know whether that is limited to approvals, is it?
I'm told it is limited to approvals.
Where is it?
It's in the authorities bundle at tab 3.3, page 146. Sorry if I misspoke earlier in suggesting that it was an order that's used more widely.
PF10.
Yes. Page 146.
Doesn't seem to say that it's limited.
No, I see that. But what I'm told is by the chair of PIBA is that it is used exclusively for approvals proceedings.
But it was used here for a non-approval. This case, the order was modelled on this, and it wasn't an approval.
Sorry, our position is that I take my lady's point about it being used in this case, but it shouldn't be, is our position, because it was designed, as I understand it, it was designed specifically to deal with the Dartford issue.
I think Mr. Weir told us that this was the order that emerged from the Dartford case, or something like it.
And we can probably take from this case, can't we, that it is widely used. Whether PIBA think that's a good idea or a bad idea, I don't know. But as my lord says, your members don't just do approvals, they do the cases themselves at all different stages.
So obviously, PIBA is conscious of the fact that other parties in the proceedings are addressing the wider issues that are raised by this case. And PIBA has sought to add value by addressing an issue that otherwise, from our perspective, wouldn't have been given any airtime at all, which we regard as a very important issue, which is whether the approach to approvals proceedings approved in Dartford should be preserved or not. Because if it's the wrong approach, then PIBA members don't want to be applying it.
Can I just ask you, I'm looking at PF10.
Yes.
Why is it called PF10? Where is it published? And what covering material exists in relation to it? Who publishes it? When was it published? What is it?
I'm told that it's in the White Book, and it's a form that appears in Part 21, which is with approval proceedings.
So the answer is I publish it. I mean, is it as part of the civil procedure rules?
Well, that's potentially quite a thorny legal question.
Well, look, I'm going to get out. It's against all my principles.
I can't see it actually as part
I'm
of Part
actually
21.
going to get the white book out, if you can tell me the page at which it is to be found. I will.
I'm told it's certainly attached in the electronic version, but you're now going to ask
Did
me
you-
where
did
it
you-
is in the hard copy version.
It's referred to in the King's Bench Guide, which I've been diligently researching. And in paragraph 4.15 of the King's Bench Guide 2025, we're told Practice Form 10 provides a draft order intended for cases in which an anonymity order is being requested in accordance with JXMX and Dartford at the stage of approval of damages application. And it gives a link.
Well, Practice Form 10 is not in CPR Part 21, and that's not to say it's not referred to, because of course, unless we look at it electronically, we have no idea. Perhaps I'll ask ChatGPT what it says.
So I'm told it's in the High Court forms in the electronic version of the White Book.
Form PF10, titled Anonymity and Prohibition of Publication Order, Anonymity and Prohibition of Publication Order, so both not withholding, is not a part of the main civil procedure rules itself, but rather a form used in conjunction with CPR Part 39, specifically concerning hearings in open justice. It is used to apply for orders that protect the identity of children or protected parties in legal proceedings. And it says this form is used when applying for an anonymity order under 3924, which allows the court to order that the party or witness's identity should not be disclosed if it's necessary for the proper administration of justice and to protect their interests. Well, if we'd read that before, we wouldn't have needed to hear this case. It's a template.
Yes, and it's referred to also in the notes in the hard copy version at 21.10.12.
Thank you.
The reform of anonymity orders, it's page 629 of the White Book.
Does it say anything about, yes, Dartford?
So it analyses Dartford, and then it says about 2/3 of the way down on 629, for a form of anonymity order which may be adapted for use on approval theory, CPF 10, anonymity and prohibition of publication order.
But there's nothing limiting it to approval orders. And indeed okay, well, I would like to know, please, possibly after lunch, what gives it effect. I mean, it's not part of the rules, apparently. What authority do the forms have, and what is it said precisely to cover in the published documentation? I mean, this publication is Sweet and Maxwell, not the CPRC.
Well, we'll certainly look into those issues, but for our part, PF10, which, as we understand it, was adopted in conjunction with discussion with various High Court masters, is a document that was born out of the Dartford case, and specifically to deal with the Dartford issue, which is how privacy applications fall to deal with specifically in respect of approvals proceedings, reflecting the particular features, the rather unique features of those proceedings. And
But except, as my lady said, it was done here, and as I understand it, this is not unique.
well,
I mean, there was much fluttering in the Dovecots about this case, but it wasn't an approvals case.
no. I'll obviously look into the issues over lunch that
Okay,
the court
good.
has highlighted. All I will say is that, from our perspective, the document was generated to deal with the approvals issue, reflecting the matter that was in issue in Dartford, because Dartford was not concerned about anonymity applications generally. with the specific problems that were thrown up by the 2110 procedure, which is what I was going to come on to address the court on.
Okay.
So there are a number of important aspects of the Part 2110 jurisdiction that ought to be noted at the outset. First, that provision was very clearly enacted so as to protect the interests of children and protected parties. I'm going to refer to such persons compendiously as protected persons. CPR 21.10 creates a situation in which a settlement agreement involving a protected person must come before the court so that the court can satisfy itself that the relevant agreement adequately protects the interests of the relevant protected person. So importantly, the jurisdiction which the court is exercising under 21.10 is not the classic civil justice jurisdiction, where the court's adjudicating on civil disputes between litigants, and nor is it the criminal justice jurisdiction, where the court is adjudicating on whether a person has committed a crime. It is instead very clearly and importantly a protective jurisdiction akin to the parens patriae jurisdiction of old. In effect, through 2110, the court is involving itself in the private settlement business of the parties so as to ensure that the interests of the protected person, protected persons of course being the most vulnerable members of our society, so as to ensure their interests are properly protected. And yet the jurisdiction under 2110 has this potentially very problematic aspect. If appropriate privacy safeguards are not put in place, the exercise of the jurisdiction risks being positively harmful to the interests of the vulnerable people it is intended to protect. And that is because the practical effect of 2110 is to force protected persons into a position where they have to expose what would otherwise be their private settlement business to judicial scrutiny, which in turn means that absent the application of appropriate privacy measures, those arrangements are, by dint of the 2110 process, exposed to the full glare of open justice. Importantly, therefore, the effect of 2110 is to place protected persons at a material disadvantage in privacy terms when compared with capacitous litigants, because of course capacitous litigants can routinely settle their disputes in private in the absence of any judicial intervention. So in effect, therefore, the question which the Court of Appeal was seeking to tackle in Dartford is where an application for anonymity has been made specifically in respect of an approval process to protect the interests of the protected person, how should that application be approached, bearing in mind these unique features of the 2110 regime? And the Court of Appeal's answer to that question is comprised within paragraphs 27 to 35 of its judgment, which starts at page 638 of the bundle. I'm going to assume that the Court has already carefully read that passage. And what we see from that passage is that when answering the question of how anonymity applications should be approached, specifically in the context of approvals proceedings, the Court took into account two key considerations. First, it would be decidedly perverse if a jurisdiction which was created so as to protect the interests of the most vulnerable members of our society ended up harming them by exposing them to adverse privacy consequences that non-vulnerable, capacitous litigants could readily avoid. Second, and relatedly, unless the courts were prepared to level the playing field by applying privacy measures where sought on behalf of the protected persons would likely suffer discrimination at the hands of the court, contrary to Article 14 of the Convention, read together with Article 8, because in the absence of privacy safeguards, the compelling effects of 2110 produces a result whereby protected persons suffer adverse privacy consequences which capacitous litigants can readily avoid, thus creating a situation in which they are perversely, doubly disadvantaged. And it was these core considerations which then leads the Court of Appeal to conclude, in summary, that in the context of the balancing exercise that falls to be undertaken, whilst each application would need to be considered individually, normally it would be necessary to derogate from open justice, irrespective of the approvals process, so as to protect the identities of protected persons who are forced to submit to that process by making an anonymity order. And further, the court held that it was not necessary in the circumstances for protected persons to evidence an actual risk that they would be subject to exploitation were anonymity not to be granted. It was sufficient in the court's view that permitting open justice with respect to the approvals process would, in the absence of relief, involve injustice in the form of a discriminatory interference with the Article 8 rights of the protected person. Although the court also said that evidence of a specific risk of exploitation would likely amount to a further reason why anonymity should be granted. So in effect, the court took the view that having regard to the unique factual and legal context to which the approval regime gives rise, the approach was strictly necessary and otherwise justified to avoid protected persons being positively harmed by a process that was intended to protect them, and further to ensure that when it comes to the protection of privacy rights, the most vulnerable members of our society are in effect placed on a level playing field alongside capacitous litigants, so the court itself is not adding discriminatory insult to injury.
So what's the conclusion? I mean, accepting all that,
Yes.
the conclusion might be, so Dartford is not applicable to this case at all, is quite irrelevant to this case, and anything the judge said about it was obiter and irrelevant because it's a completely different situation. Do you say that?
So that is obviously an avenue that is open to you. I invite you to engage with the substance of the criticisms made by the judge below, because it's important that, certainly from PIBA's perspective, that its members and their clients in the court know whether the judge's criticisms are sound.
Right.
Because if they are, things need to change.
Yeah, and the criticisms are just summarised.
So I was going to come on to that.
Well,
but I'm
we're
conscious
going
it's
to
1
adjourn in a
o'clock.
minute, so just let us go away with them in our head.
Well, it may short circuit things, or I mean, I can proceed more quickly if the court reads particularly carefully paragraphs 108 and 114.
108 and 114.
Mr. Justice Nicklin's judgment, which embraces the meat of the matter so far as PIBA is concerned.
And you disagree with those criticisms?
We disagree with those criticisms.
Okay. Fine. We'll resume at 2 o'clock. And how much longer have you got?
So I think I was, we were allotted an hour for our intervention.
Right,
I take
okay.
the view I don't need that long, but I would hope to finish certainly by 2:30.
Very good. And then we have Miss Greeny, and then we have a reply. Is that right?
My Lord, yes, I'm pretty anxious it should be as long as 2:30. We've got a slightly off the one side issue going on from PIBA. You haven't heard from the Advocate Court, and I'm determined to make my submissions in reply.
Half an hour, though.
Yes, my Lord.
You're happy
that,
with
that would give the Advocates to Court 1 hour and 15 minutes, which is not very long.
What do you think about that, Miss Greeny?
Well, I'm conscious, my Lord, I'm here to assist the court, and you have my written submissions. I mean, I have got further submissions to make, particularly on the various questions that were sent through on Monday. I appreciate the argument has also developed further.
Yes. I would say that it has. I wouldn't try and address only those questions.
No. I wouldn't be proposing to do that. Yes, I mean, it's always terrible asking an advocate how long they're going to be. I thought I will certainly do my best in an hour and a quarter. It does feel a bit tight.
Well, Ms. Proops, you're going to have to be pretty smart about it because
I'll condense.
Yes, because we're a little bit doubtful about how much we will concentrate on the approvals process in a case where the approvals process is not directly an issue. But I completely accept Dartford, since it's been accepted as applying elsewhere, is of great importance.
Yes, I
Good.
should just make clear, our position is we've always been clear that this was the issue we were addressing. That's what we've addressed in our written submissions. We don't address the wider issues that are raised on the facts of this case.
Well, interveners always get accused of going outside their remit, so we can't accuse you of that.
Well, that's